Thank you, Mr. Chairman. I'm Jerry Elmer. I'm a senior attorney at Conservation Law Foundation. We are strongly in favor of this bill. And I'd like to address two specific portions of it. First is the one that Lynette was just discussing that begins on page 3, line 34, and runs all of page 4. As Representative Keeble said correctly, it has long been in Rhode Island law that the town of Burrillville, the town council, gets to make a tax treaty with any proponent of an electricity facility in Burrillville. All this does is it sends that tax treaty to the voters for a vote. We are litigating, CLF is litigating in the Energy Facility Siting Board against this plant and the PUC. And the Energy Facility Siting Board had a site visit in Burrillville this past Monday for the lawyers. And Invenergy's lawyer explained to me why this section on page 4 of Representative Keeble's bill is so bad and shouldn't be passed. It's a very simple argument, and you'll see through it immediately. What Invenergy's lawyer said to me on Monday was, this is bad because it'll prevent all infrastructure from being built in Rhode Island all over the state. You couldn't even do a tweak to the Johnston landfill if this provision went through. The reason that it's wrong is that this amendment on page 4 of Representative Keeble's bill addresses a long existing underlying statute, Rhode Island General Laws 44-3-30. It applies only to Burrillville, only to electricity facilities in Burrillville, and it only means that tax treaties that the town council comes to has to go to a voter referendum. That provision doesn't even necessarily kill the Invenergy proposal, because if the town council in Burrillville comes to a tax treaty that the people of Burrillville approve, the Invenergy plant will be approved. That argument is just not correct. Second part that I'd like to address is on page 1, line 7 to 14. That was the first of the three matters that Representative Keeble talked about, expanding the membership of the EFSB from 3 to 9 members. And I do understand the idea behind that. It is a good idea. I have heard a lot of pushback to that idea. One of the people who will testify tonight, and he gave me permission to say this because he hasn't been called on yet, is Mike Ryan from National Grid. Grid is concerned about this. He will speak for Grid. I am not speaking for Grid. But Grid is concerned about this because it makes the EFSB much more unwieldy and difficult to get projects going. Conservation Law Foundation's view is that the provisions in this bill on page 4, giving the people of Burrillville the right to vote on a tax treaty, is so important, so extremely important, that if the main pushback that this legislature gets is to the provision on page 1 expanding the board, then strip that portion out and pass the rest of the bill. It's that important. Finally, in response to Representative Marcello's question earlier about what it would mean in terms of timing of election, as you know, the ISO New England is the grid operator for the 6 New England states. And as you know, they run this annual capacity auction where they have people offer to sell electricity into the market. When we see power plants looking for permits, they can do that in one of two ways, and both ways are common, both ways are legal, both ways are acceptable. And both ways, by the way, have risks. They can go to the ISO first and get that legal obligation and post the bond, and then later try to get a permit. And if they don't get the permit, they lose their bond, and it's a big risk. Or they can go and get the permits first and delay getting the capacity supply obligation from the ISO and probably forego some money for the first year or two of the plant. Both ways are okay, both ways are legal, but Invenergy chose for reasons that they thought were good, to go to the ISO first, get the capacity supply obligation first, and take their chances later with whether or not they would get a permit. If this bill passes, a tax treaty will be reached before this general election, and that tax treaty would be on the ballot in November. That would not delay Invenergy because the EFSB won't even have their proceeding done by then. So in the real world, that will not delay Invenergy, but more to the point, the election to go to the ISO and get that obligation before it gets permits was an election that Invenergy made for reasons that they thought were good and is not the uniform method that power plant companies use when building a new plant. So they made that bed, they ought to lie in it. Thank you very much.
Rep. Marcel, you have a question?
Thank you. Just a couple questions. If this bill, my understanding is that this plan is already in the application is already before the Energy Siting Board, correct?
Yes. Invenergy filed the application on October 29th, 2015. On January 31st, the EFSB sent to sister agencies requests for advisory opinions, and the EFSB ought to be making a decision on the permit sometime around Thanksgiving.
So I guess so if this bill were to pass as written today, from your perspective, would it be prospective only? I mean, they've already before the board that is constituted already. I haven't seen anything in this legislation that says we're going to go retroactive. So the question is, if it were to pass, and again, this is all new, and I just, for the record, I live in Scituate, so I'm somewhat familiar with the controversy because I read the paper. But I'm just curious as to, that first question is, where does this leave the applicant if this bill were to pass? Do they start again, or do they already have legal rights to the application that's already been submitted based upon the Energy Siting Board that existed at the time that the application was submitted?
Rhode Island cases on the due process clause, procedural due process clause, and the Rhode Island due process clause is substantially the same as the federal 14th Amendment, suggest that the property right that attaches to Invenergy is to have its application considered by the EFSB and not have to refile it. It does not mean that the EFSB has to be constituted at the time of decision the same way as it was constituted when the application was formed. For example, there are 3 statutory members of the EFSB: the chair of the PUC, the chair of DEM, and the head of statewide planning. That latter seat was not filled at the time of the application. That latter seat was not filled at the first EFSB hearing, at the second EFSB hearing, at the third EFSB hearing. Then the governor nominated Parag Agrawal. He took office, and he has been at those hearings. That's not unusual. It doesn't violate procedural due process. He can read the transcript. He will read the transcript and will be fully eligible to vote. So Rhode Island Supreme Court procedural due process precedent suggests that if this bill passes, additional members of the board could be nominated, sit, and vote without violating legal norms in much the same way that Parag Agrawal is sitting now and wasn't earlier.
Okay. Thank you for that. The other question I have is, if it goes to referendum, and let's assume that the voters turn it down, it doesn't mean that the project is dead. It just means that they don't have a tax treaty. They would be taxed at the 97% of the assessed value or whatever it is, right?
That is emphatically correct.
Okay.
All it means is that the tax treaty that the town council reached was not approved by the voters.
And it would just default to the regular taxation
It would
statutes of the
default
state.
to the regular taxation statutes that are in place.
And I guess if the company was willing to pay that taxation rate,
then this bill would not stand in its way.
does not stop the plan.
This bill would not stop or stand in its way in that hypothetical.
And while we're just on the technical part of this bill, on page 4 of 5, line 3, it says the town of Bearville is taxed by the town at a rate less than 100% of its taxable value. I believe that should say its assessed value. There's no such thing as a taxable value. It's an assessed value. Just for the staff.
I can say in all candor that I did not draft that sentence.
No, I'm sure you didn't. Just trying to dot the i's and cross the t's if we get while we're here. Okay, so I'm correct then. So if a referendum fails, if this bill were passed, referendum fails, I guess at their election, the company would have the right to pay 100% of the assessed value as any other company would.
Yes. And
I guess the hope would be, however, that it would be so high that they wouldn't want to build a plant.
That is a risk. And there is nothing in this bill that would preclude the town council from entering into further negotiations, coming to a new tax treaty, and putting that new tax treaty to a vote. All this bill does is say that when the town council comes to a tax treaty with a power plant, the people of the town of Burrillville have the right to vote on it, as Representative Keeble said, as the people of every other city, town, and municipality in the state of Rhode Island now have the power to vote on it.
For electric plants.
For electric plants. It's not such a radical concept. What this bill is trying to do is to restore what the General Assembly meant to do when the underlying bill was passed.
Thank you.
Other questions for Mr. Elmer? Thank you very much, Jerry.
Thank you very much.